720, which requires that you keep those records. But I've seen, sort of abuse on the other side where, for whatever reason, those records have disappeared. You can't recreate them for the most part.
Yeah, absolutely.
You could go back and copy copies of your audits maybe, but, unless somebody's got a great memory from 40 years ago, you're not going to recreate minutes. So.
And here again, okay, that's the case of the missing records. Okay, here's the last typo, and then we're going to get into policy. Website access. We've had condo reforms by way of mandatory website posting requirements, at least for associations that have in excess of 150 units or more. Do we even need official records requests? Is everything now available by website?
No. Not everything, not every official record is required to be on the website. And on top of that, you're only required to have a website if you have 150 units or greater, which is a huge disservice to our condo owners that live in associations with less than 150 units. I often find that it's the associations with less than 150 units that are potentially corrupt with boards that are stealing money, and they get away with it because it's a smaller association. Maybe they're self-managed. Maybe the majority of the population is elderly. Maybe the majority of the population are foreign investors. But that is accurate from what I see is many times it is the smaller associations without as much oversight that are the corrupt ones.
So we don't really have all the requirements for posting. And what about Kaufman? What about the Kaufman language? If, let's say, an association is 150 or over units, but they have, Bob, you can address this about the Kaufman, they don't have Kaufman language. Does that mean that even the larger associations don't have to comply with the official records statute?
I'd have to go back and look at the statute again, but I thought with the website provision applied to all associations of 150 units.
Okay.
Regardless of the declaration, but I'd have to go back and look at it. But I think that if the statute doesn't currently provide that, it should. And I agree with Spencer, and I know Jason has worked on legislation in the past, which would have required almost all associations to have a website. It's not that expensive anymore to create a basic website, and somebody can upload documents on the website. So that they're accessible, and the typical association website would have logins for unit owners, so that certain information is not available to people who are not unit owners, for example. And I think that is something we're in 2021 that there's really no excuse for not having that type of access.
So, but even if we had website access for all, let's say we opened it up and Jason was able to implement some legislative reform to say every association, regardless of size, must have a website. It's still all the information that you would be required under the Condo Act to post on the website does not necessarily cover what are, the broad-based official records, right? Even if you had full requirement or mandate to have websites, you still would need official records inspections, correct?
Yeah, I think that this is something that could be changed as well. I think that if the association provides the records electronically, I think they should have an out. And I think it's attractive for the unit owners because they don't have to make a request and go in and figure out what time they're going to go and sort through boxes and boxes and boxes and bring their own scanner in even. And then from the association side, they're saving time, they're saving money. They don't have to deal with record requests, which can be a pain in the butt for them. So I think that having it all there is just going to make this entire thing streamlined and painless. And I just think it's so antiquated the way it is now. It really needs to be updated.
Okay.
If I may, Dana, I want to make a comment because I represented a group of owners in a large sort of multi-condominium association, which had a website, and a lot of their documents were on the website, but the labels of the documents were incomprehensible. I mean, there's got to be some organized way, minutes or contract with ABC Electric or whatever. I mean, you had to open up every document to try to figure out what it was. So there needs to be rules also about organizing and proper disclosure and proper labeling so that unit owners have easy access to the websites and can understand, there's a section for contracts and a section for minutes and documents and bids and so forth, so that, it's appropriate access. It's good access.
Okay, Jason, now the floor is yours. Now we're going to get into.
No, I don't want the floor, but the website for me is, I'm like thinking of Mayor Wiseman, whispering in my ear when we talk about these things. It's not a big deal. This is not a big deal, and it's the truth. How many of you use Amazon.com? Okay, you're not making any physical inspection, purchase anything. You're doing it on your phone or your laptop or your desktop, and it gets delivered to your door, and it's wildly efficient and it works. So here's my point. The second question I asked Secretary Beshears a year ago was, listen, some associations are going to say, we're only 10 units, we're only 25 units, we're not the big, expensive, fancy places, okay? And I said, Secretary Beshears, when we have this town hall, I need you to call that bluff if somebody complains about it, and I need you to offer to host that website. So you can go with the a la carte plan, and most management companies are going to find a way to host this anyway, or the association is going to do it on their own, server or space or outsource third provider. But I didn't want anyone to complain that there was a cost barrier, that it was cost prohibitive to do it. So I said, would DBPR be willing and able and amenable to hosting an association's website? And he said, absolutely. So there's no excuse. Okay, that's number one. The filing thing is absolutely true. I always think of The Firm. Remember with Tom Cruise when they try to bury him in his first case and they go, here's discovery. And you open up a boardroom filled with 150 boxes and he's looking for one piece of paper. So the point is, yes, there's a reasonable amount, but it does exactly what Spencer and Bob says, which is the following. I get phone calls from a lot of you guys because the manager is just being nasty to you, or you're being nasty to the manager. We get phone calls from management companies too, okay? And that acrimonious relation, how wonderful it is, and I use Amazon, that you can be in your bathrobe, okay, drinking peppermint tea at 3 a.m. because you're sleepless, and you'd like to go through the records. Like you're bored and you want to go through the records of the place that you live in. That's wonderful. Forget this crap about 45 miles. You got to wait till they're ready. We're going to open the door. I'm not going to show. That's crap, okay? They should be absolutely available. It's 2021. We should click our way right to this information. We should live in an area of sunshine, figuratively and literally, and make all of these things available. The beauty of this, as a former prosecutor, is it's per se your duty. Then it creates a presumption that if it's not there, the records are not there, some funny business is going on. And that's a great position to be in. There are always more unit owners than there are association members or board members or managers, okay? So the rights of the many, of the majority, is to have open and free and unfettered access to those records. Now, the only thing that stings is the initial period of scanning these things and properly putting them in folders. That stinks. But I can assure you that 1 week that it takes will save hundreds and hundreds of man hours every year of having to field and accommodate and make appointments for and concessions and accommodations to show people the records, which are not efficient anyway. That's a no-brainer. I know that we have some groups that think my bill is a chilling effect on volunteerism, but I've known some pretty professional people that take it on because this is your greatest asset. This is your future. So nobody can convince me otherwise that it just doesn't make sense from every single condo association to do so. That's it.
Okay, so
I want to jump in there 1 second because I definitely agree with you because I have association clients where either the manager or a board member is literally got a full-time job responding to record requests. And why should they have to do that? And why should you be paying your manager to do that? Or why should a board member, if you're self-managed, have to do that when everything can be on the website and you don't have to deal with all of that nonsense? So that's a great suggestion. Everybody has a website.
So, okay, so now I think, okay, we're all in agreement. We should have greater accessibility through website and through the internet and electronic records. The voting records, the electronic voting legislation that happened more recently, how quickly though are associations to really adapt to it? Like what percentage of associations do electronic voting. And if they don't do even electronic voting, how are you going to get them to put up their websites? Like, is the pushback all about money, or is the pushback about, hey, I just don't have the resources, I can't do it? Well, what's the great challenge? What's the great impediment? Is it just slow to adapt to an electronic age, or what do you think, Jason? What's the problem here?
Well, the only other thing that's a worse system set up to sort of eat itself would be like the criminal justice system, where we have defendants pay for all court costs and fees and fines and everything like that. And that low collection rate is supposed to go ahead and fund all of the operations for public safety. The second worst is condo associations. So if the Lepsetters ever finally prevail, and they should, otherwise I may go down there with a guy named Tony, who has no last name. It's the worst kind of abuse, because the wrongdoing of those people that you voted in, you end up paying for it. On a small scale and a large scale, Mayor Wiseman will tell you a story, unrelated but kind of analogous. A few homeowners gave a developer a really hard time about something, and now everybody's slapped with a special assessment to pay for the actions of a few. So they are playing with house money. They're playing with your money. And then you end up having to pay for it. Or on the alternative, which is even more punitive, you live in a 72-unit building in the Boca area with a $500+ a month association fee, and you get slapped with a $222,000 legal bill from a large law firm, beginning with B and the other one is P. I mean, come on.
No name.
It shocks the conscience. It should shock your conscience. It should root at your core. It should shake your core about how inequitable it is. And the dispute arises, the genesis of some of these disputes are like $400. We've seen ones that are $800. Balloon up into, the prevailing party getting, the one thing Spencer has to admit is he probably thought I was using hyperbole or exaggerating for effect when I started throwing out some of the numbers and the amounts of legal fees attached to these cases. Be honest, Spencer, didn't you? And then when you looked into it, you're like, my God, some of these are like 6 months worth of the entire association fee for the condominium is the amount of dispute in question. It's crazy. Yeah. And it's inequitable. And it doesn't happen anywhere else. Okay? Courts of competent jurisdiction, Dana, you know this, Bob knows this, circuit courts, it would shake them at their core to see the amount in dispute might be $460 or being off by a day on your official records request and suing. And then all of a sudden you're slapped with a $75,000 to $150,000 legal bill. I mean, this is nuts.
There was a case that went through all the reptiles, and Bob, you know about this case as well, that everybody got. It was kind of a cautionary tale. The judge really admonished. It was an HOA where it was a landscaping dispute for $2,000 or $4,000, and then it ended up being a $200,000 prevailing party attorney's fees for a $4,000. I mean, think about the equity of that. $200,000 in legal fees for a $4,000 landscaping issue. That's really what it was. So let's talk about what's in your proposed legislation. How does this dovetail into official records, and why are you getting pushback? Or what are some of the challenges, Senator Pizzo, that you're facing with this particular reform, and why?
I think some of the particular challenges are some of the law firms that are involved in this business donate heavily to people's campaigns. For good or bad, most of you watching who are my constituents are stuck with somebody who can't be influenced by a check. I got to follow my heart, and I'm a dog with a bone. I mean, that's just the bottom line. So when we first proposed this bill, you know this is sort of a rhetorical question. The largest law firm in this space sent out an email to like 12,000 association managers and interested parties saying that I'm looking to lock everybody up, and it's going to have a chilling effect, and it's detrimental. And then, my retort is the law-abiding, well-intended person has nothing to fear ever.
Well,
tell us in that position.
Tell us a little bit about this bill. So we had there was some legislation that was circulated amongst the condo attorneys, the reptiles, and it's
listen, Marco Rubio, came out with a big proposal about this many years ago. Okay, many years ago. I think I saw Lydia nodding her head. I think she knows what I'm. Many years ago, Marco Rubio came out with something. But what really triggered for me is I had just finished at the state attorney's office, and there was a final report of the Miami-Dade County grand jury that came out exposing all kinds of problems, all kinds of issues. So it became like a menu, to pick from. What issues are, most relevant or most prevalent. And listen, it's universal in the sense that it extends to Broward and Palm Beach County and other areas that, that have these issues. And then it was just kind of like I wanted to not shift the burden, but I wanted to be fair in a sense that, like, now that things are economical, that they're not cost prohibitive like we talked about with the website, things are not difficult anymore, storage is not an issue, people are accessible and global and all that stuff, that some of this is a no-brainer. But then I also wanted to really address the gray areas. And here's what I mean by the gray areas. I see Christine's on here, so her place is a perfect example, okay?
Oh.
I'm so sick and tired of finding out ad nauseum now that the GC hired to do the lobby, mysteriously the same tile and renovation's been done in the association members unit. It's getting so tired. The problem is the way it's written, and back and forth with John. We included John Pericles from the state attorney's office, who really feels very sympathetic for. I mean, I see another person on here. She probably doesn't want me to call her out, but I know that her association manager uses the association Amex to buy Victoria's Secrets for his girlfriend. Please tell me what the nexus is between Victoria's Secrets on the Association American Express card, okay, and anything going in the lobby. Do people cheat and buy $2,000 worth of flowers and bring half of them home or resell? Yes, but that's easier to get away with. You try explaining Victoria's Secrets to anybody and how that has to do with association business. But the gray area is the following. I can, under the current law, if I get a contract for $1.5 million to redo your lobby, okay, and I want to thank you with a Rolex or redoing your kitchen, that's not illegal. The only time it's illegal is if the actual contract is $1.2 million and I puff it up to $1.3 million to pay for your present gift or whatever it is. Good luck proving that. Okay, it's the bottom line. Other shady stuff. When we have to intervene, and Mayor Wiseman knows this, I kind of get her blessing before I do something, because very often if it happens within the four corners of her city, sometimes I got to call a board president and be like, stop the shadiness, okay? I know the people that got ballots, and I know the people that didn't get ballots. I want the ballots delivered to everybody by tomorrow. Give me the time so I can hold you to it. Like, I have to do those things. We shouldn't have to. There's 4.5 million condominium doors in the state of Florida. And at one time, Spencer will tell you, there was only 38 inspectors for 4.5 million condos. And how unfair we kept, and this is one of the things that we have to press on, and we could use everybody's support. You guys pay your $4 per unit, that gets rated every year and put in for something else to go pay for something else. For some other pork on something else somewhere else, like the Sadowski Affordable Housing Fund, which gets rated every year for something else less noble. And that's one of the things that we have to insist upon, is that the money you're paying, how many of you know that part of what you pay every year goes to the Department of Banking and Professional Regulation?
Part of
it. And do you know that it gets rated most of it gets rated every year and not used for its intended purpose? No. Enid knows that. Okay. So the website's a big thing for rebuttal presumption. And I do actually seek, instead of what Spencer said before were some civil penalties or civil issues, I am seeking to criminalize bad actors. If you are committing intentional acts to defraud, to hide, to escape. So it starts with the presumption everything goes up online or everything's easily accessible. And then if you're found to have not made it available because you were hiding, you're getting in trouble. We want to define this. Remember, the association members are not public officials in the sense that they have, they have a general obligation, ethical and moral obligation, fiduciary obligation, but not one that's subject to criminal penalty if they grossly violate it, or what you would think would be gross violations of it. So that's an important issue. I'm also really looking to and I don't think it's going to have a chilling effect. Like Mayor Wiseman's husband, Steve, has served on the board. And it's like when people talk about term limits, there's some people that you can't wait till they get out of office. And then there's some people that's like, God, I hope that guy never goes away because I wouldn't want to do what he does and put in the hours. I won't do it. But that's one particular issue.
About the official records, you got some pushback from the condo lawyers about the official records part, and isn't that related to some sort of a manager certification or affidavit?
So under the I think it's the 463 statute that you mentioned before, right? For managers, the reason why I posed the question about does the obligation survive the relationship? I think if you're duly licensed and CAM in the state of Florida, I think whether or not your relationship happens to extend, let's say for the full 7 years, I think it is incumbent upon you, if you maintain your licensure, that you should also maintain the records, even if you no longer have a relationship. And the reason being is it's not an onerous, overwhelming task. It doesn't create an economic hardship. But if you did business for a period of time with XYZ condominium and you still remain a licensed property manager in the state of Florida, I think you should retain those records. A lot of professions have to, okay? I forget what it is for like medical stuff, but I've changed dentists in my lifetime. And for some period of time, they kept my records. They would transfer me, if necessary. A lot of places. Listen, I don't care how old you are. If you give me a week, I can get your school transcripts. I'm being serious. I can get your school transcripts. It might be a microfiche for a couple of you, but I can get them. So why the hell is it so hard to find something from 3 years ago in a management company you fired, dealing with millions of dollars a year? The excuses are, and this is the first question you asked me. There are some people who make a very good living on selling fear, on selling how complicated something is, that only they can do it and they're professionals at it, okay? It's how people win elections. It's how people get hired. It's how people keep their spots. To create the illusion that things are so complicated that you need a professional at it and you'll pay a premium for it. It's really not. It's really not. And there's a lot of people who are in anticipation of stuff like this, not happy with me and don't like that I'm around. I'm okay with that.
Jason, when will we see the bill?
It'll be posted on, I had to do a little charming and convincing for one of the leadership people in the Senate, Kathleen Pasadomo. She's a senator. She's now the majority leader. She'll be the next Senate president, and she's on board. I mean, she knows something's got to happen. Sometimes there's a little pride of authorship. I reach across the aisle, I think, pretty well, but there's sometimes some pride of authorship that they would prefer maybe, a particular party do something. And again, I've even offered, Senator Baxley has a condo bill as well. I'd be happy to slap everything onto his. And also, Secretary Beshears was very helpful in kind of like telling everyone to calm down. I know he's a freshman Democrat, but he's in the mix of it and he's reasonable and he understands, the legalese of it. So the position that we're in is I think we have the full force and effect, the blessing of DBPR to do something, which by extension is, serves at the pleasure of the governor as an appointee. And the other side, also agrees. I wasn't joking when I said Senator Brandis calls some association members sleeper cells of Al-Qaeda.
Okay, we're looking forward to that bill. Spencer, I want to get to you for a couple seconds, and then I want to go to the chat because we have so many messages here, and they keep rolling in, and I haven't been able to address them because we've been kind of engrossed in this conversation. Just a couple of quick questions for you, Spencer. My association flat out refused to produce the bank statements. Even worse, some of the backup pertaining to their general contractor that they just hired. Can the association or the manager be held criminally liable for their failure to produce?
Criminally liable, probably not under current laws. There's very few situations where you can go after these people individually and criminally.
What about, what's the difference between filing a complaint with the DBPR and filing an arbitration action? How does that work? And Bob, feel free to join in after Spencer.
Sure. So a complaint with the Division of Condos, Timeshares, and Mobile Homes is just that. You're filing a complaint, whether that's a financial issue on behalf of the association or election misconduct or a failure to provide records after you've made a request. They then assign an investigator, they'll look at it, and then they can sanction the association. Unfortunately, that means that you're going to be partially responsible for that payment. Now, on the other hand, arbitration is different. Arbitration is like a mini court case where it's you against the association. And there's a whole procedure there. It was designed to prevent things from going to litigation and to keep the costs way lower than they would be had they went to litigation. Unfortunately, it doesn't always work like that. It's probably not a perfect system. And what I see is if the association loses in arbitration, the ones that want to keep fighting can just file, basically appeal it to actual court. So it's certainly not a perfect system with arbitration, and I have my own ideas, and I'm looking forward to being involved and hopefully bringing some positive changes to the division with the arbitration.
Okay, great response. Bob, complaint or arbitrate?
I mean, it really depends on the circumstances. I mean, sometimes it's more expeditious, easier, more cost effective to make a complaint. I have on behalf of some clients who have requested records from associations. We sent it by certified mail. We don't get it within the 10 business days, wait a little longer, and then file a complaint with the Bureau of Compliance and send them a copy of the request, along with a copy of the green card to prove that it was received. The investigator, local investigator, there's an office in Miami-Dade County, in Doral, there's an office in Broward County. They'll contact the unit owner or the attorney and whatnot, and advise that they received the complaint and they're going to investigate and reach out to the association and ask for a response. So, I mean, sometimes they're doing it withholding intentionally, sometimes they're not. I think the division used to be more inclined to educate and don't do it again. I think they're finding more. Spencer, maybe you could address that than they used to in the past. But sometimes getting those letters from the division, cures the problem, or at least gets the boards and managers to do what they're supposed to do. And those letters and the findings that you receive from the division are become official records of the association, which have to be maintained.
Okay, so it's really the first line of offense is really to file that complaint. You don't get those records in 10 days, you don't go into arbitration. You're basically going to file a complaint and see, and the DBPR is going to jump on that, right away.
Well, I mean, they generally do. I mean, it's really just sort of a decision you make. You're going to go the administrative route, by filing the complaint, or do you want to send your pre-arbitration notice and give them time to comply? And then if they don't, then you file your arbitration petition. That could go on for months and months and months and months.
Is there
It's not supposed to, but it does.
Is there any reason why you would want to file an arbitration action straight up rather than file a complaint?
I think maybe if there's been serial abuse, you've made 5, 6, 7 requests, then maybe you would do that. I'm not sure. Spencer, what do you think?
Yeah, well, I think there are certain situations where you would not be eligible to file a complaint, that it would be necessary to go to arbitration. Like if you're challenging the association for making an alteration, which you believe was a material alteration, right? That you can't make a complaint about that.
Right, that's correct.
Yeah.
Right. Because as you indicated, I mean, there are 3 areas. It's financial issues, elections
and record requests.
Record requests where you can file, go to the Bureau of Compliance or the division, but anything else, you'd have to do arbitration.
So it's kind of hybrid. You're saying, oh, there's an alteration, and by the way, they didn't give us all the bids, or they didn't give us all the records, and you would kind of.
It's like the compliance will enforce the law, and they're investigators, right? They're not judges. They're not going to look at your legal argument and say, okay, you're right, you're wrong. Whose interpretation of the documents is correct? That's not what the Bureau of Compliance does. So when you get into that gray area of the law, now we're hearing arguments on both sides, and especially when we're interpreting governing documents, that's not something the Bureau of Compliance is going to do. That has to go to arbitration, which is essentially a mini court case.
Okay. All right. Who issues subpoenas? Last question. Who issues subpoenas, and how does the subpoena power work? And under what circumstances are subpoenas issued? Hopefully
I will soon, if I and Senator Pizzo have our way. But for now, it is with the division, and I believe it's somewhere in 718. It might be 501. And what it says is if you've made 2 record requests and the 10 days elapsed on the first one for them to provide the records, then you made a second one and the 10 days elapsed on that one, then you can file the complaint to the division, and the division at that point will subpoena the records. I'm working with the division, and we are creating the infrastructure such that I can recommend the division to subpoena records, and it doesn't have to go through the division in the same way that it has done before. So, like I work with, like I said, half the people in this group approximately, and I don't think that any ombudsman prior to me has had that sort of relationship with the division where they're recommending enforcement action, recommending subpoenas. So I'm excited to have that sort of relationship.
I think that's really wonderful. So it's really the division has the authority to issue a subpoena. It's not like I could just go into court and say, hey, I need those records. I'm going to go to the judge. I have to go to you guys, and then you're the one who issues the subpoena, right?
Yeah.
The division, the DBPR. Wonderful.
And I have a question. So, so you're a unit owner, you make your records request, and the association provides you with, the records to review, and you decide you want copies. What's a reasonable copying cost if the association is doing it itself? And can they charge you for the time that they spend making the copies and organizing the records for you?
I believe they can. I believe there's arbitration cases on that. I believe they can. And I believe, I'm trying to remember the amount of cents per page. If either of you
I mean, I've seen 25 cents, 50 cents,
Yeah, I think like 50 cents is what I saw. 50 cents per page is what I saw, I think.
That's absolutely correct. Okay, now it's time for chat. First and foremost, Pizzo, next Florida governor. Woohoo! Senator Pizzo, you got a lot of condo supporters here in the, when it comes to condo, you got
Hold
a lot.
on, I have one more special treat for a number of you.
Who's anybody
Hold
join?
on. One more special treat. One more special treat.
Somebody's joining.
Popping in. It's Maggie.
Hey, Maggie. Maggie's in the house. Maggie. Nice.
Maggie's there.
Maggie, nice.
So,
All right, thank you,
listen,
Maggie.
just to,
the
yeah,
hero.
go ahead.
She's the hero. She's the unsung hero, right?
Yeah.
Okay. Senator Pizzo, thank you for joining us, and thank you for your service to our community.
Let's get to the questions.
Okay, Spencer, you're going above and beyond what anybody's done before. Maggie is the best. Let's see, sorry guys, I got so many. Okay, we want to wrap this up pretty soon. Lack of transparency. Are you going to address a collusion between property managers and the board?
Yes.
Okay. Okay. Should all official records be in the website for condos with more than 150 units? We've talked about that, which makes the associations with less than 100 more vulnerable. We've talked about that. Financial statements for our condo are always 2 months late. Is this reasonable for a self-managed condo of 177 units?
2 months late. What? I'm sorry.
The financial statements.
Yeah, no, that's way too long. Listen, guys, don't forget about the fact that, get a hold of me, send me an email, and I can call, and the worst that they can say is what the prettiest girl in high school told me when I asked her to the prom because she was a senior and I was a freshman is no. You know what I mean? And then we can find something else.
Okay.
She said yes eventually, but initially she said no.
Okay, I thought emails could only be shared if it's a quorum of board members. Senator, do it, write it up for March. Owners are at a disadvantage if they don't have access to email addresses, promoting somebody for the seat on the board. If bylaws require all records to be in the building office, is there a statute or law that overrides that and allows records to be kept in the manager's office?
That I don't know of. It's just about reasonable retention. And the other thing is, and I think of Steve Wiseman when I think of this as well. New people coming in need training, like they need to understand. And typically, ignorance of a law that's criminal is never an excuse. Like just because you didn't know what that it was a second-degree felony what you committed doesn't ever excuse anything. But lately, and as everybody understands, I think you guys just get a form and you sign off and, to say that you've actually, reviewed it. Things like throwing in like under no circumstances whatsoever should you be emailing any member, any unit owner, whatever, about campaigning or about anything. The problem is that, a guy like Steve Wiseman, if he's on his board in Aventura, might be like, hey, did you see the Yankees game last night? I mean, when does it cross the line or constitute, that kind of behavior? So you need more of an all or nothing kind of situation. If you're using that for access, everybody needs to be able to do the same thing.
Just by way of background, there's a nice little DBPR pamphlet on official records. If anybody's interested, Spencer, you can circulate, or I can, but I think they put together a nice little pamphlet on official records of condominium associations, what you have, what you don't have, and it's obviously available on the website. Who should own the website for condos with more than 150 units, the association or the property management company? I do not understand the language of 718.111.
Yeah, 1111. It runs with the condo. It runs with the building. So if we all get wiped out by COVID and someone else moves in, it runs with the building. It stays, however storage is kept, hopefully electronically and digitally going forward. My feeling is it runs with the building. Okay. So who owns it? That was the question before. The management company takes off like, listen, we're going to set you up with a platinum package. We're going to build you a website. We're going to host it. We're going to set up email addresses. And then you fire them the following year and they take everything with them. That's not cool. It's got to run with the building.
I think that's right. I think that's absolutely right. Do you agree? Everybody agree? Nod. Okay. Who should own the website for condos with more than 100? We talked about that. Let's go on to the next. I agree, it's a privacy issue. I asked my board to send an email to owners to voluntarily opt in with an email list so we can communicate with others, but they refused. My board, they don't want to be organized. They've been in power for 14 years, no intention to leave. Agree, access about emails. Our treasurer fixed all cameras and has full control of videos.
We have a lot of those situations. We also have people that are getting very close to a violation of a felony violation of 930 Florida Statute 934 with non-consensual recording of other individuals. We have some board members who send security guards basically to go film families doing things. At its core, the United States Supreme Court said, basically said, do you have an expectation of privacy, and is that expectation one that society is prepared to recognize? And while you may have access to certain areas where those cameras are, and they in and themselves are not per se private because you have open access to in a common area, it starts to borderline on creepy and predatory and like nefarious voyeurism at some point. There are people who delight in having that kind of access and make you think that Big Brother is watching. So to Spencer's earlier point, and I think Bob also echoed the point about whether or not that the review of those recordings are meant to be based on an accident or needed for some sort of investigation, whose dog really peed on the carpet, things like that.
It's funny you say that because I've been fielding requests about drones and things like that. And actually I'm piloting a condo rights workshop on privacy rights in the next couple of months. So I'm looking forward to putting that together. Jason, I'd love for you to be if you're interested in serving on that panel, whomever, but I think privacy rights are definitely, I think it's an emerging area in condo living. So we'll be talking about that hopefully in a couple of months. Okay.
Another thing, Dana, about cameras. I mean, if a building doesn't have cameras and they want to install cameras, unless there's a security need, there's been criminal activity and so forth, it's a material alteration of the common elements to install those cameras and security systems all over the place, and the unit owners have the right to vote on that. Unless you can demonstrate that there's been specific criminal activity in that area or in the building, and you're doing it for security reasons.
I think that's absolutely right. If anybody has any comments on that, I see Enid nodding her head. Absentee owners, what if there was a stalker living in the building? It's not the same as technology has changed. Renters, can association directors approve a project without consulting first with the owners? I think that answer, Bob, is pretty, what do you think?
I'm sorry, what was that, Dana?
Can directors approve, a project without consulting with the owners?
Well, I mean, all contracts have to be approved at a board meeting, which is duly noticed. And at those board meetings, all unit owners have the right to speak and comment. If the contract is to change something in the building, again, if it's a material alteration, then that would have to be put to the vote of the unit owners in most associations. So it depends on the nature. But, I advise all my association clients, don't do anything of any substance that's, without doing it at a board meeting that's been noticed, so that unit owners have the opportunity to participate.
We're running
Sometimes there's an exception, and this actually happens with cities and schools as well. As you guys know, over the past couple of years, we've had a couple scares at schools and stuff like that. I do believe in limited exception if there's like a health, life, and safety issue, but it has to be emergent and imminent, right. And then it basically expires. I mean,
or it can be ratified later on if it's
right. However, I'm inclined. Some people are uncomfortable, and I know a lot of you are told no. I'm inclined to allow people to record and make the rebuttable presumption that it's an open meeting, and that there is no. I mean, I don't believe in expectation of privacy as it relates to a condo board association meeting. But I know plenty of people who have been told, "Don't you dare!" and they're doing it like on the sly, like in their pocket, recording something.
But the statute provides that. The statute provides that if you have the right to videotape meetings, but if you give notice that you're going to do it, and you have to be stationary, you can't be walking around, and
right? But
you have the right to tape record them as well. So
you have the right to videotape, but this has come up and been discussed at prior workshops. You don't have the right to put it on YouTube, right?
If there's a closed Facebook group for ABC Oceanside condominium, you may be able to post it on that closed group, but you're right, not on YouTube or not to the general public.
And it's also the expectation of people that are participating that it won't be blasted. But we have condos right now in Miami who, if you say a disparaging word about one of the association members, it's in their rules. They will fine you. Spencer's not shaking his head in disbelief, but he knows it's true.
I've seen that as well.
They will fine you $100 as a unit owner if you say something mean about one of the condo board members on Facebook. That's actually in the rules. Folks, this is the intention of all of this. You have criminal prosecution state attorney's office over here for a clear and beyond a reasonable doubt that something's wrong here, probable cause at the very least. You have Spencer over here who's trying to be a sweet, nice gentleman. And what I'm trying to do is just make sure that they meet and there's no large gap in between. So if something needs to be referred or something like rises to the level and goes past his threshold, past his purview, or vice versa, they refer to him. Conversely, prosecutors right now don't have a Spencer to give stuff to say this doesn't rise to the level of a felony, but it's certainly unethical. It's certainly actionable by your agency. And there has never been that connection for forever, really. And that's what we're trying to foster.
Okay.
He's like Elliot Ness Jr. Light, diet Ness.
Diet Ness. Okay. Yeah. So we got a lot of other chats. I know we're running very long on this presentation, and so that just goes to show you how engaging this topic is. We're getting a lot on the chats about term limits. I think we've kind of gone through that issue. I think everybody, at this point accepts, or at least may not accept, but acknowledges, the Division of Condominiums position that the term limits is not a retroactively applied statute, and that those term limits do not start or vest until 2024. Is that the prevailing opinion about that? Everett, Spencer, Bob, Jason, we're all nodding our heads about that, right?
I think
I know there's some people that feel very, 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 very certain and firm about that idea, and they want it to be retroactive. I would almost be inclined to, I know this is not going to make everybody happy, but what happens in the sense of like nobody else wants to run?
Well, yeah, but there was the exception. I think if nobody else wants to run, then you can.
What about a 90 percentage? What about what's the percentage? Is it a supermajority? Can override
2/3 or something. If you get 2/3 of the vote, I think
it's 26, not 24, Commissioner Goldman.
Right.
2026? It's it's that far out. So it doesn't toll from the 2017.
No, it was 2018 that the law became effective, and so.
Because I think it was amended once, and then, so it's 2026, okay. Okay, last couple, my condo association doesn't provide statement of my account. Is this legal? They like to tag on the charges to disqualify prospect candidates who want to run for the board. Isn't that the idea? If you're 1 penny off, you can be disqualified?
Yes, absolutely. I see this every day.
Right.
So
and you got to file a complaint with the
Sorry. Right. So can I interject best practice? The best practice being, if you want to run for the board, get into that office and make sure that you're up to the penny, because 1 penny can disqualify you, correct?
And yes, and it's the 40th day before the election. Right. You need to be in the office that day and make sure.
Right, exactly. I tell my clients the same thing, or board members who want to run. As Spencer said, get your statement on that day, on the 40th day.
The 40th day, get the statement, best practice, because you can get knocked out of the box for very little, and it happens routinely and it happens consistently, right? Okay. Yep. 11 messages, condo rights. What if they fall out of good standing? Okay. So we're, thank you for organizing. Thank you very much. Condo corruption, dictatorship. I think we've kind of covered the gamut for official records inspections, and we've tacked on a few additional topics, but certainly Jason, Spencer, if you have all your information, if anybody's interested in this little pamphlet on official records inspections, please direct message. Jason, you have all your information. You're always very accessible, you and Maggie. Spencer, you're just doing a yeoman's job, really out there for the residents, really out there for the community. A great congratulations. You've really, you just knocked it out of the park right away. You're really a gift, really. You're just a great different, just great part of this conversation, and hopefully we'll get some reform initiatives together. And then Bob Yaffe, of course, my partner in crime. Always a great pleasure to serve on these panels with you. You just add so much in terms of your knowledge, your expertise, and your just practical information and wisdom about these topics. So I want to just give Senator Pizzo just a final word on. Can I unmute you? Just can you give us a final word before we?
Sure. I appreciate everyone's support. What I don't want to do, what's happened in years past, is cheerlead. You're here because you're engaged, because we're all on this issue together, or these numbers of issues together. I will be selfishly for the support of the bill, both in the House and the Senate, maybe asking you to do some direct calling and or emails and urging, but keep them unique, keep them simple, just sort of express the situation, and I appreciate it. Things can be amended. I know Christina asked the same question. We're going to be trying to get some final words from Spencer. We'll have several weeks to go ahead and make additions and amendments on things and get this through. But I appreciate everybody. I am accessible, but so are you guys, and you're engaged. So I appreciate it.
Terrific. Wonderful. Spencer, any other comments? Bob, any other? I think we've pretty much covered some of the.
Yeah. I wanted to bring up the topic that former Representative Julio Robina brought up on the last one, which was the condo law task force. What I have found is that it has been at times difficult to get buy-in from the police, and either they're not interested in condo issues or they don't have the resources for it, whatever the reason is. I feel that if we were to have this task force that would be dedicated to condo issues, that it would be one of the most beneficial things that we could do for condo owners in the state.
Well, let's just have another workshop about it fairly rapidly. How does that sound?
Yeah, absolutely.
Okay, wonderful. Well, thank you again, everybody. I see a lot of familiar faces. Thank you so much to our esteemed panel. Wonderful condo rights workshop. Let's just keep rolling along, and let's see some real reform happen in our condo laws. Thank you so much.
Thank you, Dana. Thank you,
Thank
Jason.
you, everyone.
Thank you, everybody.
Thank you, everyone.
Thank you.
Good night.
Thanks,
you.
everyone.
Thank you, everyone. Bye.
Bye. Okay.
When the top.